Losing a loved one is one of life's most challenging experiences. Amidst the grief and the process of healing, families are often faced with the daunting task of navigating the legal complexities of their loved one's estate. The probate process can feel overwhelming, especially when trying to understand the associated legal costs. Our goal today is to demystify probate lawyer fees, providing clarity during a difficult time. Please remember, this video provides general information and is not legal advice. For personalized guidance, always consult with a qualified attorney. When a loved one passes away, you might hear the term probate. Simply put, probate is the legal process of administering a person's estate. It ensures that their debts are paid and their remaining assets are correctly transferred to their heirs or beneficiaries under court supervision. Some estates are relatively straightforward, especially if there is a clear, simple will and few assets. But things can get complicated quickly. If the estate involves varied assets, like commercial real estate, active business interests, or sprawling investment portfolios, the process becomes much more demanding. This is usually when you need a probate lawyer. An attorney guides the executor through a maze of legal requirements. You will want legal representation if you face complex assets, potential will contests, aggressive creditor claims, tricky tax issues, or if the person died without a will, known as intestacy. A lawyer takes the heavy burden of executor duties off your shoulders. When hiring a probate lawyer, understanding how they charge is critical. You might encounter 4 common fee structures. The most common is the hourly rate. Here, the attorney bills you for the exact time they and their staff spend on your case. This is standard for complex estates, where the total work is hard to predict. Next is the flat fee. Some attorneys offer a single, fixed upfront price for handling the entire probate process. This structure is generally reserved for simple, straightforward estates, where no family disputes are expected. A third method is charging a percentage of the estate. In certain states, state law dictates a statutory fee schedule, meaning the lawyer receives a specific cut of the gross estate value, regardless of how much time the process actually takes. Finally, we have contingency fees. These are rarely used for standard probate administration, but apply if you are contesting a will. The lawyer only gets a percentage if they successfully recover money or assets on your behalf. Whichever fee structure applies to your situation, clear communication is crucial. Always discuss billing upfront and ensure you sign a written engagement agreement that outlines every single cost. When navigating probate, understanding how lawyer fees are calculated is crucial. Several key factors impact the final cost. First is the size and complexity of the estate. A simple estate with a single home is far less expensive to probate than a massive estate with diverse assets and investments. Location also plays a major role. Legal fees in major metropolitan areas are typically higher than in rural towns. Next is the experience level of the attorney. A seasoned probate lawyer charges a higher rate than a junior attorney, though their expertise might resolve issues faster. Whether the probate is contested or uncontested makes a massive difference. A harmonious family process is straightforward, but family disputes or contested wills lead to expensive courtroom battles. Finally, state laws dictate fee structures, with some allowing a statutory percentage of the estate's value, while others mandate reasonable flat or hourly rates. When it comes to probate lawyer fees, your location matters significantly. Some states, like California, have specific statutory fee schedules set by law based on the gross value of the estate. For example, California allows 4% on the first $100,000 and 3% on the next $100,000. Most other states do not use a strict percentage system. Instead, they require probate fees to be reasonable. In these states, lawyers typically charge an hourly rate or a flat fee based on the complexity of the estate and local market rates. This means sliding scales are often used to ensure fairness for grieving families. Keep in mind that many states offer simplified probate procedures or small estate affidavits for smaller estates, significantly reducing legal costs and helping you avoid unnecessary delays. Because state laws vary widely, always consult with a local attorney to get an accurate estimate for your family's unique situation. Beyond lawyer fees, grieving families face several hidden probate costs. First are court filing fees, which can exceed $1,000 depending on the estate size. Then, the executor or administrator is often entitled to statutory compensation for managing the process. You will also need professional appraisers to determine the exact value of real estate and personal property. Courts often mandate a costly probate bond to protect the estate and require publishing a formal notice to creditors in a local newspaper. Finally, complex estates incur accounting fees for final tax returns and financial ledgers. Combined with miscellaneous expenses like certified mail and postage, these hidden costs quickly add up, significantly reducing the final inheritance. Dealing with probate can be costly, but you can reduce expenses. Start by organizing all estate documents before meeting your lawyer to save on hourly fees. You can also handle simple tasks yourself, such as closing utility accounts. Additionally, communicate effectively by grouping your questions into one email rather than making multiple phone calls. If family disputes arise, consider mediation, which is much cheaper than court battles. Also, shop around and compare fees from multiple lawyers to ensure you get the best value. Finally, if the estate is modest in size, utilize small estate procedures. These simplified legal processes can drastically reduce legal fees and save valuable time. Start your search for the right probate lawyer by asking friends or financial advisors for trusted referrals. Then check reputable online legal directories to find local probate specialists. With a short list in hand, read through client reviews. Positive online feedback reveals a lot about an attorney's reputation, communication style, and success rate. Next, schedule consultations with your top choices. Bring a list of key questions to ask about their specific probate experience, fee structures, and estimated timelines. Ultimately, you need to trust your gut. Choose a lawyer whose expertise gives you peace of mind, leaving you feeling relieved and confident about the path forward. Let's answer your most common probate fee questions. First, how much does a lawyer cost? It varies widely, from a few thousand to tens of thousands, depending on the estate's complexity. Can you negotiate? Absolutely. Always ask if they offer flat fees. What if you can't afford a lawyer? Look into local legal aid or pro bono programs. Also, keep in mind that probate fees are usually paid directly from the estate itself, not from your own pocket. Are you required to hire a lawyer as executor? It's usually not legally required, but highly recommended to avoid personal liability. When hiring, always ask about their specific billing structure and their experience in your local probate court. Navigating probate can feel overwhelming, but understanding lawyer fees doesn't have to be. By asking the right questions and knowing your options, you can protect your family's legacy and find peace of mind during a difficult time. Visit probateus.com/directory today to find experienced, compassionate probate lawyers in your area. If you found this video helpful, please like, subscribe, and leave a comment below. Remember, Probate US is here to help you navigate these challenging times. Thank you for watching.